Hello, good morning, good afternoon, and welcome to this round of Tech Talks in legal interoperability in data spaces today. And while getting ready for an exciting session, I would like to also first thank Söntje for being with us today. And also, as you know, in all our Tech Talks, we have them powered by some projects like BD4 Energy, Databricks, Divine, EnerShare, Zcapo, Fame, Omega X, Datamite, and Zero Swarm. And as mentioned, so today we are with Dr. Söntje Hilberg, and a lawyer specializing in IT and privacy law, and who is the chair of our Taskforce legal framework and also a legal advisor to IDSA. And in addition to discussing the topic of legal interoperability in data spaces, she will also introduce the Taskforce legal framework and its initiatives related to this matter. And please, during the call, during the webinar, please feel free to raise questions by using the Q&A tool or using the raise hand tool. So we will be having them one by one at the end of the session. So let's enjoy the session together. And Söntje, thank you very much for being with us today. And the floor is yours. Thank you.
Yeah, thank you, Anil. And I'm happy to talk today about legal interoperability. As Anil already mentioned, that's something that we discuss also in the IDSA Legal Taskforce. And I'm happy to share some thoughts on this topic today. I tried to, so I'm not sure if you can see my screen now.
Yes, it's visible perfectly.
Okay, perfect. So yes, legal interoperability. So what we want to discuss today, or what I'm going to present, is first a brief introduction on legal interoperability. What does it mean? And then we go deeper into the context of data spaces. So what the aspects of legal interoperability in data spaces are. And then I will discuss some major topics and approaches regarding legal interoperability. And in this context, as Anil already mentioned, I will also give you a brief overview of the IDSA Legal Taskforce and their activities. So legal interoperability. So first of all, the term interoperability by itself is not really a legal concept, rather a technical one. And there is no, let's say, official definition of interoperability in a general meaning, but there are, of course, certain different definitions, and they are combining elements are interaction and exchange. So to give you some examples, the International Organization for Standardization, ISO defines interoperability as the ability of two or more systems or components to exchange information and to use such information that has been exchanged. Another definition that I like is the European Interoperability Framework, the EIF, and they define interoperability as the ability of organizations to interact towards mutually beneficial goals involving the sharing of information and knowledge between these organizations through the business processes they support by means of exchange of data between their systems. Regarding interoperability, the National Interoperability Framework Observatory is one of the institutions on a European level and works as a monitoring tool to gather information on the different on the state of play of digital public administration and interoperability activities. Maybe you heard of this organization. And they, according to their framework, legal interoperability is about ensuring that organizations operating under different legal frameworks, policy, and strategies are able to work together. So that means legal interoperability covers a broader environment of laws, policy, procedures, and also agreements needed to allow a seamless exchange of information and reusability of data between the different organizations and across jurisdictions, which makes it even more complex. So that's for the term of legal interoperability. And now we go a little bit deeper into the concept of this. So first of all, again, interoperability has different levels. I would say that it's, if you see interoperability in a holistic perspective, legal interoperability is only one layer. And based on the European interoperability framework, there are 4 levels. And IDSA uses also in their description of interoperability in governance these 4 layers. And we have on the one hand the legal level, that is, as I said, to ensure that organizations under different legal jurisdictions and frameworks can share data. The organizational level is to let stakeholders align goals, expectations, responsibilities, and so on. So that's the organizational perspective. And then we have the more technical levels, which is the semantic level and the technical level. So on the one hand, to ensure that the format and meaning of shared data is preserved and understood, and to provide software and hardware to exchange and share data. So the interoperability in data spaces has also 2 dimensions. We have the intra-data space interoperability and the inter-data space of interoperability. So one is like inside a data space for providing a gradual migration path within a single data space instance or initiative. And on the other hand, and as you know, there are different data space initiatives and they need to work together. So it's the exchange and the smooth sharing of data between different data spaces. And there I want to mention a recent IDSA position paper on data spaces landscape published in March this year that describes also these 2 dimensions and why it is important to consider both. Legal interoperability, on the other hand, has not only these aspects to consider, but also has different legal dimensions, I would say, itself. So on the one hand, legal interoperability in data space is not only to align different regulatory frameworks. For example, that's the topic we have on European level, where we have different jurisdictions or different regulations that need to work together. But in data spaces, it's the regulatory framework on the one hand, and or the compliance regulations, but on the other hand, also the contractual and policy framework that applies to the data space itself. And probably the biggest challenge is the consolidation of these 2 frameworks, the regulatory framework and the contractual framework. So that means in the end, legal interoperability in data spaces and between data spaces is rather complex and goes beyond the alignment of different single regulations. So to start with the regulatory framework and legal compliance, the legal fields that have to be considered when sharing data include different legal topics. As you might know, for example, we always have topics around competition law. When we use personal data, we have data protection. We have with data always security topics. And then we have IP-related topics like copyrights, patents, and so on. And that is something that always needs to be considered based on legal regulation when sharing data. And right now, based on the European data strategy, we have even a higher level of regulation expressly addressing data sharing in the EU, and the already published regulatory approaches are the already finished Data Governance Act, for example, of course, the proposal for a Data Act, Digital Markets Act, Service Act, and the proposed AI Act. And these new regulations, on top to the regulatory framework of competition law, IP, and data protection, comes on top and has definitely a big impact also on governance topics inside and intra data spaces. It becomes even more complex considering we have globally exchanged data, because then we have to consider cross-border jurisdiction, different national laws, for example, outside Europe. So if a data space operates globally, the legal framework becomes even more challenging because there is no one law covering the different jurisdictions. So therefore, the biggest challenges that we see is that the new, let's say, European regulatory framework has a direct impact on if and how data can be shared. For example, it comes with new legal rights to data access, also restrictions to share certain categories of data. And that is something that needs to be considered when sharing data. Also, we have we see overlap and consolidation issues still with the new regulation, because, for example, the DGA or also the Data Act includes without prejudice clauses regarding GDPR, and that results in uncertainty because then on the one hand we have the Data Governance Act, for example, to be considered, and on the other hand, the GDPR also applies if personal data is involved. So it is still not really clear how these regulations work together. So the different regulations still needs to be aligned while data spaces already operate. So that is something that is definitely a big challenge regarding the regulatory framework. Now, on top, considering the contractual and policy framework applicable to data spaces, it's based on the fact that there is no, let's say, EU or also national law on data sharing. So therefore, data spaces operate mainly based on different types of agreements and soft law, like policies or other regulations given by the parties. So it's still the main framework is also defined by contractual agreements. So different parties using different individual rules on if and how data is shared. So the challenge here is that there is no national contract law, EU or national contract law, at least in Germany, to foresee specific mandatory or default rules for contract. So it's still the freedom of contract that makes it different to combine different individual policies or individual agreements between the parties in one data space. Also, contract law is lacking rules on how to handle data access rights, especially by competition law or regulatory law, which will then need to be implemented by way of contractual regime. So the contract framework in data spaces needs to be needs to align different aspects that are not really defined by law. So therefore, the challenge might be that we have kind of a battle of forms. So there might be different regulations, contractual regulations inter data space that are not really aligned with each other. So it makes it more complex because we have different frameworks there. So the goal might be to develop and implement for a data space a fair and transparent common rules system that on the one hand needs to be aligned also with the organizational and technical environment of the data space and needs to cover all relevant use cases. So it's, let's say, the vision of a one-fits-all approach. I put there a question mark because that's probably something that is not really achievable in practice. A real one-fits-all approach, but the contractual framework should be open to different use cases, also future use cases. So that's really complex. And now the biggest challenge probably is that we have to combine both aspects. So we have the regulatory framework, and the contractual or policy framework needs to reflect these regulations and all applicable rules. So there are some of the EU regulations have some standard contracts or guidelines in mind. For example, the EU regarding the transfer of personal data outside Europe, you probably know the standard contract clauses that should be used by the parties transferring data. And the idea could be to have also such contracts for the data sharing in intra and inter data spaces, but that's not available yet. So certain regulations also have different direct impact on the contractual freedom. Let's say narrowing the playgrounds. For example, the Data Act comes with a number of contractual requirements. So that has also a direct impact on the outcome for a contractual framework. And also the future development of regulations is something that needs to be reflected by the contractual framework and the rules for data spaces. So the monitoring and updating of the contractual and policy framework is required regarding upcoming regulations. That is also something that is probably a challenge because it will need kind of a procedure to monitor and to update the framework. So how can all these challenges? How can we react to all these challenges? Just regarding some. I choose some of the aspects or approaches that might be interesting here. And first of all, standardization and harmonization. It's always, you know, with data, it's always about finding the balance between innovation and standardization. Because if you try to standardize everything, then it's probably not as flexible as you need to be innovative on the other hand. However, a reasonable level of standardization is probably the only way also to scale innovation. So you need a standardized set of rules to make it practical and to allow data sharing on a regular basis. Legal interoperability, like interoperability in general, requires therefore the development and use of standards and harmonized rules. So in data spaces, between data spaces, there should be kind of standardized rules, or let's say, at least harmonized rules so that the data sharing has a smooth ground and not a case-to-case approach. So therefore, legal standardization can be defined as an understanding approved by a recognized body, in this case, the data space, that provides for common and repeated application. So therefore, you have, for example, standard contractual terms, policies, also standard processes for conclusion, amendment, and execution of contracts, and the regular review and alignment process, for example, regarding, as I mentioned, upcoming regulation, but also new use cases, and the development of other initiatives, so that there is also a possibility to act inter-data spaces. So standardization, harmonization, one topic that is important to allow legal interoperability. And the approach, as I mentioned, is definitely to use kind of standard contract templates, not to negotiate for each single case, but to have something in place that allows to be used in different cases, let's say like a toolbox. The alignment with other initiatives and existing legal frameworks is also extremely important. And for example, the IDSA, as already mentioned in the latest update for the IDSA rulebook, is kind of adopts already existing contractual framework and works close with the CITRA rulebook, because CITRA already provided really sophisticated templates for different contractual situations. And we are working close on updating this on the one hand to the needs for IDSA, on the other hand, both together regarding the new EU regulatory framework, because that is something that needs to be done. Because as I mentioned, Data Governance Act, Data Act, there are certain rules that needs to be reflected in the already existing templates from CITRA, for example, and also from other. There were already other contractual frameworks, but CITRA is here one example. And of course, the future vision is that contracts may be concluded more, let's say, on a technical basis, automation, but we are not there yet. But that is something that we always should have in mind when now talking about contract templates or contract frameworks, that in the future it should be open to automation and technological practice. So one, and probably I think one of the most important topics regarding legal interoperability is the use of common terms. So what does that mean? Intra and inter-data spaces require the use of a common language to achieve, also in a legal sense, a common understanding. And I don't know, if you joined, I think it was the last Tech Talk on semantic interoperability, and also there the importance of language, let's say common language, was mentioned, and the use of a vocabulary as common language, and they also talked about the establishment of vocabulary hubs, for example. One moment. So, and I want to mention this because regarding legal interoperability, it's kind of the same, even if it's a complete other layer, but common language is also key here. The parties, especially in a legal sense, need to have the same definitions and understanding of legal terms. That's even more important when new terms defined by law, like the Data Governance Act, for example, very important in data spaces, the definition of intermediary needs to be translated into data spaces governance and into the contractual framework. So that's only one example, but it's very important to have a common use of terms. So what can be the approach regarding common terms? It's definitely the alignment between already established glossaries and cooperations with other initiatives, because if we see only the intra-data space interoperability, that's one topic. And of course, there might be a specific glossary used in this data space. But right now, and also, of course, in the future, the inter-data space interoperability is very important to allow the vision of the of one Europe data space. So towards this, I want to mention the Data Spaces Support Center, DSSC, that you probably heard of, and I will have some more information on the DSSC a bit later. But they recently published a glossary that is already aligning different language, let's say, from different initiatives, and it's a very good first step, I would say, to have a commonly used glossary for data spaces. So that is something that's probably interesting to have a look into. And then one topic that I think it's really important is, and I would say it's kind of the integrative approach. So the technical level might also help to achieve legal interoperability. And there should be always an integrative approach between the technical perspective and the legal perspective. So to give you some examples, for legal interoperability, metadata is extremely important because legal interoperability also requires that metadata enables discovery and defines the conditions and authorization for access. So metadata is I would say, like the interface between the data and the legal definitions for this data. So it's important that that metadata can be found and described clearly and readily what the legal implications around this data is. Another topic is important when it comes to personal data. So there might be a lot of use cases, and also data spaces might focus on non-personal data, but probably in the future and also today, but probably in the future even more, there can also be personal data. And of course, data protection is rather strict on such data. So it's important to have mechanisms for anonymization and pseudonymization so that this data can be used. So that's also a more technical approach regarding a legal topic. So that's, for me, I think, another example on or where technology jumps in to help legal interoperability. And you know, how does that happen, or what are the aspects in practice? I can give the perspective from IDSA, and the availability of metadata, for example, is one of the core concepts of the IDS. And it enables data owners to describe their data and make it available for data processors. So the other topic of anonymization of personal data is also reflected by the IDS, because the connectors need to be capable to anonymize data packets on different levels, or there are different options how to do that. But the idea of anonymization serves here as an instrument for data minimization and avoids the processing of personal data where possible. So that is also an instrument to help use cases to make it legally compliant in practice. So another topic is that I mentioned before, important for interoperability in a legal sense, is the monitoring and discussing of legal topics. So existing and also upcoming legal topics need to be identified and discussed to update the existing legal framework. The intra and inter data space approach requires also the alignment with other initiatives and experts in the different legal fields. So the approach also from IDSA is to share know-how and ideas on such concepts, on updates, also from the regulatory side, and to share it in the community. So to use and help each other by way of open source, I would say, and such ideas and know-how can be shared based on, let's say, different platforms or working groups or whatever. And IDSA is organized in that way, so we have different working groups. And also regarding the legal topics, IDSA uses its task force. And I will describe in a few how the IDSA Legal Task Force is organized, or what we care about. So that's you know, as I mentioned before, I want to give you like two deep dives. One is the Data Spaces Support Center that I mentioned, and yeah, just to give you a brief overview, the DSSC is funded by the European Commission as part of the Digital Europe program. And to see the setup and operate of the Data Spaces Support Center, it's really complex, and it covers also a lot of topics. But part of its mission is the enabling the availability of technologies, processes, but also legal frameworks, standards, and tools for the deployment of data spaces. So it's really, it covers, let's say, the full life cycle of data spaces. And therefore, you know, as I mentioned, the glossary is really something that is the first step regarding the work package of legal interoperability. And this topic of legal interoperability is expressly mentioned by the DSSC, and for example, by the design of a legal compass building with a user-centric approach and focus on inter alia legal interoperability. So the idea of the DSSC is really also to push kind of, or to come up with guidelines for data spaces regarding legal interoperability. And I think I'm curious, and I am pretty sure there will be more outcome in a bit by the DSSC, and that is definitely an instrument that can help to align the different legal frameworks that I mentioned before. So the IDSA Legal Task Force is a task force, and we defined two different activity fields that we see as important for IDSA on the one hand, and of course the community. So in the first one is, we called it public voice. This is more like, you know, creating content, and it's especially important regarding, I think, inter-data space and cooperation with different initiatives. So to, you know, publish ideas or concepts or something that we discussed in our task force meetings. So there we try to draft position papers or impulse papers, articles, and so on, or to share ideas on social media, so that we get also feedback from the community, or can go deeper into certain topics. And the other activity field is more, let's say, the practical approach. We call it task and solutions, and that is the identification and solution of specific tasks related to legal domain. That means we support IDSA working groups. For example, we work very close with the rulebook working group, because this is also important for the legal aspects in this rulebook, but also with the other working groups, because of course in data spaces on the, you know, in the other levels, organization or governance or technology, there will always be questions linked to legal topics, and that's something where we try to support IDSA, but also discuss tasks and solutions with other initiatives. We meet quarterly with the task force, and see, we always have we have speakers for certain topics, for example, but we also work on the current activities, but focus on these two activity fields. And to make it more, you know, really to see it more as a real activity and a work stream, we defined different subgroups, because I think there is no one, let's say, legal topic for data spaces. It's really rather very special topics. And for the beginning, we defined 4 fields that might be most important from a legal point of view. So we have 4 subgroups right now. One is compliance, ethics, and regulatory framework. There we discuss and work on especially the new regulation on data sharing that I mentioned before, but also on ethics, which will probably also become more and more important as, let's say, a soft law in data spaces. So that is, let's say, all around the regulatory framework that I mentioned before. It's also important to have this subgroup to track new developments, and also to discuss, for example, the topic of global data exchange. So this is covered especially by this subgroup. Then we have the subgroup for contracts and data usage control. Also very important, because this covers the second dimension I described before. It's about the contractual framework, and it's about the combination of legal and tech. So it's also about data usage control, also from a technical perspective, and therefore this subgroup is as all the subgroups, but is not only for, let's say, legal people. We also need technical expertise here, and to combine the cross-functional perspective on this topic will become especially important soon, I think, when we discuss smart contracts or automation. Third subgroup is about IP and know-how. also very important. And as I mentioned before, maybe one of the classic topics for data spaces. So there are topics like data ownership that doesn't exist, but topics around who owns the data and how do we handle derived works, IP management, and patents. So it's all about the IP related topics on data. And then the last subgroup is especially the topic that we discussed today, legal and interoperability and harmonization and standards. So how do we handle the alignment of legal regimes and roles with data spaces, and what kind of, how can we push standardization and harmonization in this field? What are the current developments in this field? So it's a subgroup especially about this topic. And of course, all the subgroups work, they kind of overlap. And the subgroups meet every month to see where they stand with their activities and so on, and they report then in our task force so that everybody is always up to date also on different topics. So that is that's the concept of the legal task force from IDSA, and it's really work in progress. And we are very happy if even more people join. So it's open really to join this task force and every subgroup. Yeah. So, and that's so far everything from my side. And Anil, I think probably I didn't focus on the chat, but maybe you found some questions.
Yeah, thank you very much, Söntje, for the great presentation. And so currently we don't have any questions raised in the Q&A. So I encourage and welcome all attendees to raise their hands and then unmute yourself and ask a question. So maybe we can wait a little bit for this one, and I think some questions will come.
Hello, may I? Can you hear me? Katarzyna Barot here, University of Vienna. Thank you very much for a great presentation and for tackling the topic of the legal aspects of data space. That very often the topic that comes after the technical developments, whereas I think that it's relevant that it goes hand in hand. And regarding the task force and the assignments that the task force of IDSA has, I would like to ask you, in what manner the entities that are not part of IDSA itself could get involved in the work of the task force legal? Specifically, I'm talking about this public consultation that you foresee, whether anything of this kind, any meeting that would be organized for this type of collaboration is foreseen to take place anytime soon or not? How would you plan to inform external entities about the next steps and actions? I'm very much interested in this because, well, I would have interest in joining this. Thank you.
So Anil, maybe I start, but Anil, you probably can also talk about this. But as far as I know, we are happy to collaborate also with non-IDSA members, and because, as I mentioned, especially regarding the legal topics, I think it's an inter-data space perspective. So it's not really only for, let's say, for IDSA, but especially to align with outside the organization. So we are definitely open to this. And regarding, you know, the public topics or something that is especially not only relevant for IDSA, we plan on having or to publish also reports from the task force about the activities and what we see is coming up. But anyway, everybody is absolutely welcome to join the task force meetings, for example. And we always share also the information that we receive or that we create in the task force.
Thank you very much. Thank you.
Yes, and thank you very much for showing your interest. We will be also sending the necessary information after the webinar. I see another raised hand from Tom, but is it correct?
Can you hear me? Loud and clear. All right. Yes, thanks for the presentation. I have a very practical question. We're working on a couple of use cases for building a, let's say, proof of concept of a data space. Very hands-on with a certain data set. It's AIS positional data of vessels and of ships. Think GPS locations, but then of ships. And we bounce into a lot of legal questions, a lot of which are mentioned today as well. And I was wondering, the DSSC was mentioned, the International Data Spaces Task Force was mentioned. If I have very practical, concrete questions, are those two parties also the ones I should contact, or how can I go about this the most efficient way? Do I just fill in a form on their website, or how can I ask for help from a very practical perspective to build it, let's say, up and tackle the problems that we or the challenges, let's say, that we mentioned today, to tackle them, let's say, from the ground up? What would the best approach then be?
Yeah, that's a good question. I mean, it's I would try to explain it. It's, let's say, if you are having like really concrete legal questions, it's not that IDSA Task Force, for example, works as a let's say lawyer service or something, right? So that is not what the task force is for, but it's definitely, for example, a forum to discuss those questions with others who might also have the same, right? Usually you will not have like problems or questions that nobody had before, or you know, it's more like probably a common question. So that, of course, that can be something, for example, where you present in the task force what you are doing, what the use cases are. That could be a forum. The DSSC is also, as far as I know, but Anil, maybe you have another insight, but from my perspective, is also not yet, nobody knows about the future, but not yet a service provider. It will rather come up with kind of standardized solutions and answers. So it's more like an FAQ approach than the individual advice. So that means, as an answer, if you need individual advice, that's usually something where you have to ask for individual advice from somebody who, like a legal expert. But to discuss, I think both can work as a forum. But if you really need like detailed answers for your case, it's usually a typical advisory situation, and that is both organizations are not. It's not the approach, let's say.
So then I'm reading between the lines that commercial parties would be more, let's say, suitable to advise rather than both organizations that you mentioned. Okay.
Yes. To get first ideas, I think something like the Task Force Legal is something where, for example, if you have a brief presentation on your topic, we can definitely discuss. So maybe afterwards you could just contact Anil and me, and we can discuss if this is, for example, something that gives you at least some ideas and can also be very interesting for others. So that is at least our approach, to always try, of course, to also help for specific use cases, but always with the idea of also to make it available to others who might have the same questions, right?
Okay, yeah, I'll gladly share the use case and a couple of the issues that we're facing. Will you share the presentation or your contact details afterwards, or how can I go about this best way?
I don't know, Anil,
yes.
What's your...
We will be sharing the presentation after that, after the webinar, and but we may also contact you. I mean, we already have the email address, so we can send a reminder.
Nice, greatly appreciated. Thanks.
Thank you. You're most welcome. And we have another raised hand, but before that, we had a question added to the list. So which is from Kei Fujinami, and the question is, I think that Catena X will cover the global supply chain. It's needed to create legal interoperability. Would you let me know the current status of consideration of legal interoperability on Catena X?
Was that a question, or?
Yeah.
Because as far as I know, Catena X, they obviously also discuss legal interoperability, but it's you know, it's maybe for Catena X then, but it's not like it doesn't solve the all over topic of legal interoperability. That's what I mean. But they do have an approach, and it's really valuable to use what they already developed. Yeah.
Perfect. I think we can go with the next one. So Marta Gutierrez.
Hiya, can you hear me? Okay, I have two questions. You may not have the answers of it because they can be very specific or very generic, but anyway, I'll have a go. I saw in one of your slides that you mentioned that there needs to be a translation of the data intermediary definition from the DGA into data spaces. I would be very interested in knowing if this translation has been done. I've checked the glossary of the Data Space Support Center. There is a definition in there. I am not sure this really reflects the DGA definition to the greater extent, but for sure, there's been many discussions as to whether data space are data intermediaries themselves, and whether these are in fulfillment with the DGA. That's my question number one. I can put the question number two to get it out of the way, or you want to reply as you wish. My question number two is whether there are any recommendations in the establishment of legal entities, and whether there are any patterns developing in terms of the contractual agreements, whether a specific legal entities would map into well-defined patterns of contractual agreements, and whether this activity is going on in any of the subgroups or task agreements. All the data spaces, CSAs, we need to declare what kind of legal entity we're going to establish in there, and whether any particular contractual agreements with patterns defining these contractual agreements would fit a specific legal entities for best in one occasion or the other. I hope that makes sense. I'm happy to repeat or go back or explain that. Yeah.
No, definitely both. I think, let's say, fundamental questions for data spaces. So maybe regarding intermediaries, the translation into practice and to define who is the intermediary, or is there an intermediary between all the different service providers in data spaces, or is the data space, I say, operator itself, the intermediary? That is, as I see it, an ongoing discussion, because to be honest, the definition of intermediary, and by the way, my understanding is that the DSSC defines it aligned to the Data Governance Act.
Okay.
So it doesn't, the glossary doesn't say they don't have a direct reference to the DGA, but it's from my understanding, it's the same definition. And this role that is defined by the DGA is to be further specified. And I'm pretty sure that, for example, the DSSC will have some recommendation on that in the future, but from IDSA perspective, the let's say organization that defines the data space, in our case an association under German law, is not the intermediary itself.
Yeah.
Right? So some of the roles inside a data space, for example, a data broker, can be an intermediary. That's at least, you know, the perspective I would say that I personally have on this, but the data space itself should not be the intermediary. And I'm pretty sure that is also not what the Data Governance Act had in mind when defining this. Though I have to say I'm not so happy with the definition. The definition itself is one thing, but it's not really aligned with other definitions. So I think it's hard to understand who has which role in data spaces, because the DGA also describes different other services related to data, and that needs to be matched with the data space governance in different scenarios. So yeah, that's still for intermediary, I think, an ongoing discussion, and definitely something that is not, there is no one answer for every data space. But for example, if building a data space right now, this is one important aspect that should be defined. Which role is an intermediary and which is not. So, and then regarding the second topic, and I understood the question that, like, what should be the legal entity for, let's say, the governing entity for the data space, let's say the data space operator, and I think it depends on the purpose of the data space and the parties or members that want to join the data space. So, for example, IDSA is an association, so a non-profit association that is especially the legal entity. So it really depends on the use cases that the data space wants to operate. This would be this is a topic that is definitely something that the subgroup, so we didn't discuss this there, but our subgroup on contractual frameworks will cover not only, let's say, the contract situation for single data sharings, but also the all-over topic of the contractual framework around or for building data spaces. That is, I think that was your question also, right?
Yeah, it was not exactly like what kind of legal entity. It's like whether you can see, because there are different, as you rightly answer, that depending on the purpose, you would establish one type of legal entity or another. But the type of legal entities, they're kind of well known. Yeah, there are so many different things you can create legally, right? So my question was more towards whether there are patterns between the different types of legal entities, and we can create contractual patterns matching those types of legal entities. That was more the answers to us. An association, you will have one way of doing these contractual patterns, but if you create an ASBL, or if you create a different type of legal entity, whether contractual patterns and will emerge that will help all this legal interoperability as well.
Yeah, but it's definitely a very important topic, a very essential, I would say, topic. So maybe the same. I think that could be really something that is interesting to discuss in the task force. So if you are interested in raising the topic, we should definitely discuss. I think it can be interesting for others as well. So Anil, I think we can also put this on the list. That's really good.
Yeah, thank you.
Well, thank you very much for all your great questions, and thank you, Söntje, for the great presentation and the answers. So unfortunately, we are out of time, but as said, so we will be sharing the slides with you, and then please feel free to keep in touch. And thank you very much all, and have a great rest of the day.
Thank you.